Hello friends, if you are divorced over 60 or helping a parent who went through a divorce years ago, there is a Social Security rule you need to check before you assume the monthly check is all there is. But before we go any further, listen carefully to this first distinction, because this is where many people get confused. If your former spouse is still living, the divorced spouse benefit question usually starts around age 62. But if your former spouse has passed away, the surviving divorced spouse benefit question can start as early as age 60 in many cases, or age 50 if the person has a qualifying disability. You hear divorced after 60, do not hear that as one single rule. Hear it as a warning to check which category you are in. Living ex-spouse, one set of rules. Ex-spouse, a different set of rules. And that difference can change what you ask Social Security. This is not a trick. This is not a guaranteed extra payment for everyone who was divorced. And it is not automatic for every person who had an ex-spouse. But for some people, especially people who were married for at least 10 years, Social Security may need to compare more than one record. Your own retirement record is one record. A current spouse's record is another. A divorced spouse benefit is another category. And if a former spouse has passed away, survivor benefits may be a completely different question. That matters because many divorced seniors only ask Social Security one simple question: what is my retirement benefit? But the better question may be, am I eligible for any divorced spouse benefit or surviving divorced spouse benefit on my former spouse's record? And how does that compare with my own benefit? That one sentence can change the conversation. Here is why this matters. Many divorced seniors, especially women who left the workforce for caregiving, raised children, worked part-time, or had years with lower earnings, may have a smaller Social Security benefit on their own record. They may not know that a former marriage can still matter under Social Security rules if the marriage lasted long enough and the other requirements are met. And the mistake is not always that Social Security calculated something wrong. Sometimes the mistake is that the person never asked the right category question, never applied under the right benefit type, or assumed the divorce papers ended every possible Social Security connection. Before we go through the 5 parts of this rule, if you are not subscribed yet, subscribe and turn on the bell. Social Security, Medicare, tax rules, and retirement benefit mistakes can be confusing, and many seniors are never personally told what to check. This channel breaks it down in plain English so you can ask the right questions before money is missed. Now let's walk through this carefully, because this topic is one of the easiest Social Security topics to misunderstand. Number 1, your own retirement benefit is not the same as a divorced spouse benefit. Your own Social Security retirement benefit is based on your own work record. Social Security looks at your covered earnings, your age when you claim, and the rules that apply to your own retirement benefit. A divorced spouse benefit is different. It is connected to a former spouse's Social Security record, but only if certain conditions are met. The big condition most people hear about is the 10-year marriage rule. If your marriage lasted at least 10 years before the divorce became final, you may be able to ask Social Security whether a benefit on your former spouse's record applies. But notice the careful wording, may be able to ask. That does not mean every divorced person gets more money. It does not mean every person who was married for 10 years automatically receives a larger check. And it does not mean you get your own full retirement check, plus another full divorced spouse check on top. This is where many people make the expensive mistake. If you already qualify for your own retirement benefit, Social Security generally compares what you are entitled to on your own record with what you may be entitled to as a spouse or divorced spouse. If your own benefit is already higher, there may be no additional amount. If the divorced spouse amount is higher, Social Security may pay your own benefit first and then add an extra amount to bring you up to the eligible level. Think of it like a comparison, not a double payment. For example, suppose someone receives a retirement benefit based on their own work. Then they ask Social Security to compare it with a possible divorced spouse benefit. If the possible divorced spouse amount is higher, the person may receive an added amount, but they should not assume they will receive 2 full checks. That is not how this usually works. This is also why a friend's story may not apply to you. One divorced person may get an additional amount. Another divorced person may get nothing extra because their own retirement benefit is already higher. A third person may not meet the marriage length rule at all. The action step here is not to guess. Check your current benefit type, then ask Social Security whether any other category should be compared. Number 2, the 10-year rule matters, but age 62 and early claiming rules matter too. The phrase most people remember is married at least 10 years. And yes, that is a key rule for divorced spouse benefits, but the 10-year rule is not the only rule. For a divorced spouse benefit while the former spouse is alive, several questions may matter. Did the marriage last 10 years or longer? Are you currently unmarried? Are you at least age 62? Is your former spouse entitled to Social Security retirement or disability benefits, or at least eligible under certain circumstances? Is your own retirement benefit lower than what may be payable through the divorced spouse category? That is why two people can both be divorced and both over 60, but only one may qualify for an additional amount. Here is the part that needs to be said clearly. Age 62 does not mean full benefit. For many Social Security, retirement, and spousal-type benefits, claiming before your full retirement age can reduce the monthly amount. Reduction can be permanent for that benefit. So if you are 62, the question is not only, can I apply? The question is also, what happens if I apply now instead of waiting? This matters because some people hear about an ex-spouse benefit and immediately want to file, but filing early can lower the monthly amount compared with waiting until full retirement age. The right choice depends on your health, income, work plans, marital history, and the exact benefit category Social Security is reviewing. Do not let a YouTube video, a neighbor, or a family member rush you into claiming early without understanding the reduction. The practical step is to ask Social Security for the comparison at different claiming ages. Ask what the amount looks like now, what it looks like at full retirement age, and whether filing for one benefit affects another benefit. Here is another detail many people miss. If your former spouse has not filed for benefits yet, that does not always end the question. In some situations, if your former spouse is at least 62 and eligible, and you have been divorced for at least 2 continuous years, you may still be able to receive benefits on that former spouse's record if the other requirements are met. It matters for people who assume, my ex has not claimed yet, so I cannot ask. Do not assume that. Give Social Security the facts and ask them to review it. And there is another narrow detail for people who married the same person more than once. In some situations, marriages to the same person may be counted in a special way if the remarriage happened within the required time window after the divorce. That is not something most people should try to calculate from memory. If that sounds like your situation, tell Social Security the full marriage and divorce history and let them review it. Homework for this section is simple. Gather dates, not guesses. Write down the date you married, the date the divorce became final, whether you remarried, and whether you later divorced again. If you have the marriage certificate and final divorce decree, put them in a folder before contacting Social Security. Number 3. Divorced spouse benefits are different from surviving divorced spouse benefits. This is the most important correction for the over 60 crowd. If your former spouse is living, you may be asking about a divorced spouse benefit. In that situation, age 62 is usually the key age to discuss, but if your former spouse has passed away, the question may become a surviving divorced spouse benefit. That is where age 60 can become very important, and in some disability situations, age 50 may matter. These are not the same conversation. Survivor benefits, Social Security has separate rules. In many cases, a surviving spouse or surviving divorced spouse may be eligible starting at age 60, or as early as age 50 if they have a qualifying disability if the other requirements are met. Ex-spouses who were married for at least 10 years may also be eligible in certain cases. This is why a divorced person who received nothing extra while the ex-spouse was alive may still need to check again after the ex-spouse dies. A living ex-spouse benefit and a deceased ex-spouse survivor benefit can be treated differently. Many people never check again. They were told years ago, your own benefit is higher, and they assume the answer can never change. But the death of a former spouse can change the category being reviewed. That does not mean everyone gets more. It means the question changes. For example, suppose a woman was married for 24 years, divorced and never remarried before age 60. Her own retirement benefit may have been higher than any divorced spouse benefit while her former spouse was alive. But after that former spouse passes away, the survivor calculation may be different enough that she should ask again. Do not assume the old answer still controls the new situation. If your former spouse has passed away, ask Social Security specifically about surviving divorced spouse benefits. Do not only ask about retirement. Do not only ask about regular divorced spouse benefits. Use the correct label. Also remember that survivor applications may be handled differently from regular retirement applications. The issue involves a deceased spouse or deceased ex-spouse. Contact Social Security and ask how to apply. Prepare the former spouse's name, social security number if you know it, date of birth, date of death, marriage information, divorce information, and any benefit letters you already have. If you do not know the former spouse's social security number, Social Security may ask for other identifying information. Number 4, remarriage can change the answer. This is another place where people accidentally get bad information from friends, relatives, or random online comments. For divorced spouse benefits while the former spouse is alive, being currently remarried generally matters. If you remarry, benefits paid on a former spouse's record may stop or may not be payable while that later marriage continues, depending on the situation. But survivor benefits have a different remarriage rule. For surviving spouse or surviving divorced spouse benefits, remarriage before age 60 can affect eligibility. Remarriage after age 60 may still allow possible survivor benefits on a deceased spouse's record, or possible benefits on a new spouse's record. The right answer depends on the exact situation. This is why you should never make a marriage decision based only on something you heard in a video. Do not delay remarriage, rush remarriage, or change your personal life because of a generic explanation. Social Security rules are important, but they must be applied to your own facts. The action step is to write your marital history in order. First marriage date, divorce date, second marriage date if any, second divorce date if any. Date a former spouse passed away if that applies. Current marital status. When you call Social Security, give the full timeline. Do not leave out a remarriage because you think it does not matter. Let SSA decide what matters under the benefit category. This is especially important for people who are married, divorced, remarried, widowed, or divorced again. The timeline can change the answer. Number 5. Asking about this does not take money away from your ex-spouse. Many people feel uncomfortable asking about a former spouse's record. You may think, I do not want to take money from my ex, or his current wife will be angry, or my divorce agreement said we each gave up claims against each other. But Social Security is not the same as dividing a bank account in divorce court. A divorced spouse benefit is part of the Social Security benefit rules. Asking about eligibility does not mean you are walking into your former spouse's bank account and taking their monthly deposit. This is especially important for older women who spent years raising children, caring for family, or supporting a household in ways that did not always show up as covered wages on a Social Security earnings record. Do not let embarrassment stop you from asking a legitimate question, and do not let old assumptions stop you either. A divorce paper may divide property, but Social Security has its own rules about who may qualify for benefits on a record. If you are unsure, ask Social Security. Do not rely on a sentence from a decades-old divorce agreement without checking how Social Security applies the law. The second step here is to get organized before you call. You may need proof of birth. You may need a marriage certificate. You may need the final divorce decree if applying as a divorcist. You may need information about your former spouse, including their name, date of birth, Social Security number if known, and the dates and places of your marriages and divorces. Social Security may not need every document immediately, but having the folder ready can keep the call from turning into confusion. And here is one more important point. Do not delay asking just because you do not have every document in your hand today. Social Security can tell you what documents are needed. The mistake is not asking at all. Now let's put this into a simple example. Suppose a woman is 67. She was married for 23 years, divorced, and never remarried. She worked, but many of her working years were part-time because she raised children and cared for family. She filed for Social Security on her own record because that was the only record she thought mattered. Years later, she hears about divorced spouse benefits. She should not assume she automatically gets an increase, but she also should not assume she gets nothing. The right move is to ask Social Security to compare her own retirement benefit with any divorced spouse benefit based on the former spouse's record. Now suppose another person is 61, divorced, and the former spouse is still living. That person may be very close, but they should understand that divorced spouse benefits while the former spouse is living generally involve the age 62 rule. The smart move is to prepare documents, check the record, and ask what would happen at 62 and at full retirement age. Now suppose a third person is 60, was married for 15 years, divorced, never remarried before age 60, and the former spouse has died. That person should not ask only about regular divorced spouse benefits. They should ask about surviving divorced spouse benefits, because the deceased ex-spouse category may be the relevant one. This is the entire point of the video. The label matters. Retirement benefit. spousals, divorced spouse benefit, surviving divorced spouse benefit. Those are not all the same thing, and when people mix them together, they either panic for no reason or miss a benefit they should have asked about. So here is your clean checklist before you contact Social Security. First, write down your current benefit status. Are you already receiving retirement benefits? Are you receiving disability benefits? Are you receiving survivor benefits? Are you not receiving anything yet? Second, write down your marriage history. Include each marriage date, each divorce date, and whether a former spouse has passed away. Third, identify any marriage that lasted at least 10 years. Do not round up. Use the actual dates. Prepare documents, marriage certificate, final divorce decree, birth information, and any Social Security letters you already have. Fifth, ask the right category question. If your former spouse is living, ask, am I eligible for divorced spouse benefits on my former spouse's record, and how does that compare with my own retirement benefit? If your former spouse has passed away, ask, am I eligible for surviving divorced spouse benefits on my former spouse's record, and how does that compare with what I receive now? If you are thinking about applying early, ask, how much would this be reduced if I claim before my full retirement age? Those three questions are better than simply asking, am I okay? If you are close to age 62 or older and applying for spouse or divorced spouse benefits, Social Security has information connected to Form SSA-2. Some people can apply online if they are within 3 months of age 62 or older, or they can apply by calling Social Security or visiting a local office. If the question is about widow, widower, or surviving divorced spouse benefits, ask Social Security how to apply because survivor applications may need a different process. Before we close, there are 3 mistakes I want you to avoid. Mistake number 1, assuming divorce erased every Social Security possibility. It may not have, especially if the marriage lasted at least 10 years. Mistake number 2, assuming age 60 and age 62 mean the same thing. They do not. Age 62 usually matters for regular divorced spouse benefits while the ex-spouse is living. Age 60 may matter for surviving divorced spouse benefits if the former spouse has died. Mistake number 3, assuming you get 2 full checks. In many cases, Social Security compares records and pays the higher eligible amount, or pays your own benefit plus an additional amount if another category is higher. Mistake number 4, ignoring the early claiming reduction. If you claim before full retirement age, your monthly amount may be reduced. Do not file early without understanding the trade-off. Mistake number 5, assuming an old answer is still the final answer. If your former spouse was alive when you first asked, but later passed away, the survivor question may need to be reviewed. So here is the full picture. If you are divorced after a long marriage, especially a marriage of 10 years or more, do not guess. Check. If you are already receiving Social Security, do not assume the deposit is wrong, but do not assume it has been compared against every possible record either. If your former spouse is still living, ask about divorced spouse benefits and the age 62 rule. If your former spouse has passed away, ask about surviving divorced spouse benefits and whether age 60 applies to your situation. If you are thinking about filing before full retirement age, ask about the reduction before you make a decision. And if you have remarried, tell Social Security exactly when that happened, because the age and timing can matter. The safest sentence is this: can you compare my own Social Security benefit with any divorced or surviving divorced spouse benefit that may apply to my former spouse's record? That is the sentence many people never ask. Subscribe for more plain English Social Security, Medicare, tax, and retirement money alerts. Share this with a divorced friend, a widow, a widower, an adult child helping a parent, or anyone over 60 who may not know this rule exists. One careful question to Social Security can sometimes prevent years of confusion.